welcome back. Let's now talk about some of the pronouncements or decisions, if you will, judgment of the Supreme Court, the highest court in the land, which is not just the Supreme Court, it's also the Court of Public Policy. So they made a few decisions in the last few days, one of which is the fact that lottery and games are now the exclusive preserve of the states. They affirmed that decision just a few days ago because we had the National Lottery Act of 2005. That by law is no longer in existence. So if they have to do all of that, that's to be domiciled in just the FCT, since the National Assembly has direct jurisdiction, since the FCT doesn't have a state house of assembly because it's not a state, it's a federal capital territory. And also they talked about the earnings. The 36 states had taken the federal government to court, saying that the earnings from gas sales, especially LNG and all of that, it has to be accounted for, because in their argument, look, whatever is being made from our Commonwealth has to go to the Federation account, which will trickle down to all tiers of government. So, but the Supreme Court had dismissed and struck out that particular case as well. So we're calling on the lawyers to give us a fair interpretation of what this is and what it means for the polity. We're being joined on the program by an associate professor of law, public law, Rivers State University, Professor Richard Nwokocha. He joins us via Zoom. Prof, thank you for coming on the program. And also,
thank you.
A legal practitioner, Mr. Stanley Ekpa, joining us from our Abuja studios. Thank you, gentlemen, for coming on the program. Prof, Prof, let's begin with you to help us make sense of how this has played out eventually, because whether you, I think what you lawyers call res judicata on this particular issue of the earnings from gas, as well as this issue of the lottery and games. Sometimes as laymen, when we look at some of these cases, we felt that there's a precedent that is already there, so why even try to adjudicate in the first place? But now the states have done what they've done, and for some they lost, some they won. So maybe you help us break down what the two judgment means for the polity.
Well, in the case of the judgment on the suit filed by the states, you have a legal principle which you just mentioned at the introduction, the principle of res judicata. The principle requires that a matter that has been settled, has been rested. So if a matter is judicially decided, it's decided and it's rested. There is no need to reopen it. And so in that case, the Supreme Court simply said, look, the Bauchi state government had come with this same request and we dealt with this issue. An objection was raised by the federal government at the time, the Attorney General of the Federation, that issues concerning revenue of the federal government, as you will find in section 251 of the Constitution, subsection 1, are within the province of the powers of the Federal High Court. So such issues on revenue of the federal government should go to the Federal High Court. The Supreme Court does not have original jurisdiction to hear such matter direct without having passed through the appropriate court that has jurisdiction in exclusion of any other court to hear such matter. And so when this matter was filed again, you look at the list, Bauchi State is among them, all the states, and they are talking about the same thing that Bauchi State talked about in the earlier case. And the Supreme Court said, look, we have dealt with this matter before now, and we have resolved on what the position is. So long as it is this case couched in this way, on this same subject matter, between the same parties, the same Attorney General of the Federation, that matter is rested. We cannot deal with it. We lack jurisdiction to deal with it. So that was his position on that case. In the case of the Lottery Act, well, there, you recall prior to this time that the Supreme Court had said a similar thing concerning VAT. If you look at item 59 on the first part of the legislative list, you find out what the federal government or the National Assembly is giving power to tax on is incomes, profits, and capital gains, except as otherwise provided by the Constitution. And so any other issue that is not within there, if you go to section 4, subsection 7 of section 4, which provides for the powers of the House of Assembly, It says whatever is not provided for in exclusive list and whatever is contained in the concurrent list falls within the province of the House of Assembly to the extent that the concurrent list provides that the House of Assembly should act on it. And so what we call residual matters, matters that are not part of the exclusive list and matters that are not mentioned in concurrent list, fall within the province of the State House of Assembly. And that's the point that the Supreme Court was making in that decision, that lotteries and such games of chance are residual matters, and they are issues that State Houses of Assembly should deal with in the respective states, not one which the National Assembly has competence to make law on. And so the law of the National Assembly will only operate in the Federal Capital Territory, where the National Assembly is the legislative body for. Beyond that, the states have to make their own lottery laws as they require and as they need it. So that's the position of the court in those two matters.
Okay, let me come to you, Mr. Ekpa, with a second critical look at these decisions. And I'd like you to enlighten us, starting with the Supreme Court decision on the Lottery Act, nullifying it. I wonder if, the federal government has this judgment is a result of the federal government, looking with very little interest in that sector, because reports say that Nigeria earns between 50 to 60 million or billion dollars per year on games of chance. So I wonder if the federal government has very little interest in that sector. That's why this judgment has come, with what seems like a walk in the park. And with regards to the Supreme Court decision on gas earnings, is this a victory for the continued efforts to call for restructuring in Nigeria, or rather, is it a loss?
Thank you very much, Bukola. With respect to the Supreme Court decision on the Lottery Act, I think it's not likely the case that the federal government do not have interest in what happens in the sector, or the revenue base, or the contribution of the sector to Nigerian revenue base. I think it's clearly, as the learned professor rightly said, it's clearly about the issue of the constitutional issue. The Supreme Court's hand, perhaps, a tie to the effect that the issue of lottery has to do with commercial activities at the local level. It doesn't fall within the exclusive jurisdiction as expected under the first schedule and the first part of the Constitution. Nor does it fall under the concurrent list. So naturally, it falls within the residual list. And of course, the Supreme Court would naturally have to interpret that to the effect that the states, the State House of Assembly squarely has the responsibility and the duty to make laws that regulates and enforces how lottery are being played in some parts. If you look at some jurisdictions, you realize the fact that except jurisdictions like UK, where there are centralized system of regulatory lottery, in some places where we have similar federal structure and system, lottery issues are actually not issues that are within the purview of the federal government or the central government. It is usually, something that falls within the purview of the subnational, the state level now. Squarely, when you talk of the issue of the decision on the gas earning, I think it's a good thing for our federal system, really, the fabrics of federalism. Number one, if you look at the fact that, the learned professor have already made mention of the fact that it's a decided matter, and of course, I agree with the Supreme Court to the extent that the matter has been squarely dealt with. And once the matter has been dealt with in the case that it aids and underscores the principle of res judicata, the Supreme Court as the final court just has a responsibility to ensure that such matter is not being re-litigated again. But what I think also that is very important is that the states now, the subnational attorney general would have a responsibility. Because to me, I think that the core issues of this current litigation is distinctly different from that of the AG of Bauchi State versus AG Federation. in AG Federation, AG Bauchi and AG Federation, I think that the issue was squarely on the presidential order of 1980 that the court had to interpret that it was it had to bother and affected the issue of the revenue sharing formula. Where I think the state made a mistake is the fact that they had to model up the entirety of what they are praying the court to do, asking the court to compel the federal government, to account on the earning, the profits, the dividends that are accrued from since the Fourth Republic till date, and also, asking the federal government to account and also to share the what they've discovered to be what has been mismanaged under the federation accounts. I think that they should have had it in mind that given the fact that the federal government have settled the issue of the sharing formula in the AG Bauchi and AG Federation, the next thing I think is that they should have gone through the institutions that are responsible really for what comes into the federation accounts. Institutions like the Federal Ministry of Finance, the Accountant General's Office, the Revenue Mobilization, Allocation and Fiscal Commission, to really have facts as to what exactly has accrued to the federation account since 1999 to date, and exactly how has the federal government mismanaged. Those are the facts to which they would have presented distinctly different that would distinguish this current case from that of the AG state and AG Federation. But largely, I think that it is a good thing for our federal, for the growth of our federal system, that we are beginning to have the Supreme Court squarely, make decisions that are final on issues of this nature.
But in reviewing the case, would it be instructive for states to take a second look at the issues of resource control, which has been a long drawn agitation in the country, such that states can make more earnings from resources within their domain? Mr. Ekpa, that's for you.
Oh, thank you. I think that has to do with a constitutional issue that needs constitutional amendments. If you're talking about the fabrics of federalism that would have to change our revenue generation, derivative principles now, that will have to change the current 56% that goes to the federal government account, the current 24% that goes to the state, and the 20% that goes to the local government account. It then requires a constitutional amendment. Of course, it is wisdom that we change the constitution to require states where the natural resources are derived to have more control of their natural resources for the development of their local development needs. But that would have to be an issue of constitutional amendment from the National Assembly, really, and not from the Supreme Court. As the learned professor rightly said, the Supreme Court, there's a limit to which the Supreme Court can do a judicial activism, to effect or to advance for such. It will squarely have to be an issue that will require a constitutional amendment, changing or making some alterations to Section 162, of the Constitution, and then, of course, Section 1 of the Allocation of Revenues Act.
Well, let me take this to the associate professor via Zoom, because I imagine a lot of people are then looking, wait a minute, if the National Lotteries Act has been voided, then perhaps there are other laws that were instituted that are against what the federation is meant to look and operate like. On the flip side is the 60 million gamblers daily, because data says from the National Lotteries Commission that 60 million Nigerians gamble on a daily basis. I'm not sure if this new decision will affect them, but it just speaks to the kind of activities that go on in the country and how these resources or the the revenue that comes out of the activities are shared, whether equitably or not. And it takes me to my question. So if we will have all of these reviews, and I know, as I said, a lot of lawyers, governments will be going through the laws and saying, which one does not work? Let's go challenge it. But then you get to the Supreme Court and you see that as of first quarter of 2024, the Superior Court had total 243,253 cases pending, and that's from the CJN. So you wonder, clearly we have a backlog of cases and there are still people clamoring for justice. Is there really an easy way out for the CJN, or let me just say the judiciary, in this one?
need to be tested. This is not the Supreme Court has spoken. There was a VAT case which the Rivers State government pursued up. The Supreme Court came to the same conclusion that VAT ought not to be a national law because it's a residual issue. It's not part of what the Constitution listed as what the National Assembly can handle. So there are a lot of laws. You recall at the end, towards the end of the military government, there was this this decree that was passed, a list of taxes to be collected by each of the tiers of government, and that was just rolled into the 1999 Constitution and relevant tax laws, rather, at the end of the military regime. Now, these things need to be revisited. What does not belong to the national government needs to return to the states. If you have enough resources for the state to deal with, there will be less agitation because states will have more on their hand to do. So yes, it takes us back to the resource control issue. There are resources that do not belong to the national space, and the states should be allowed to exploit those resources and to control how those resources are exploited. So this is just a tip of the iceberg. There are a whole lot of other laws, national laws, that need to be revisited that ought not to exist as a national law. They should only operate at FCT, while the states should have relevant laws operating those issues or regulating those issues in the respective states.
And my question, let me just ask Mr. Ekpa as well, is do we have the resources in the judiciary to properly, adequately prosecute this issue of resource allocation, right? And that's why I mentioned the backlog of cases before our superior courts. Do we have the resources to be able to properly prosecute these cases of resource allocation? Because clearly, we need more resources if we will test the waters, as Prof said.
Thank you very much, Kayode. It's a known fact that the federal government is, the Supreme Court is saddled with different cases. But again, I think we do have the resources, really. If you realize the fact that the states attorney generals are the ones, or the state attorney general is one that has the responsibility to prosecute such matters or to test the water, as Prof is suggesting. The state has the resources to prosecute such matters, and I do think that we must begin to see how we constantly test the waters. Out of the 68 items on the exclusive legislative list, if you test the waters on almost all those items, you realize the fact that the federal government to have no business having more than 40 to 35 items on that list, really. Particularly when it comes to issues of resource allocation, resource control. And so we have the resources at the subnational level to pursue and to test the water on how the state can galvanize, harness, and control its resources for the greater good of its being. Let
me let Prof have the last word on this. So we may have the resources to put up the case, to prepare the case, but do we have resources to adjudicate over those cases? And that's why I mentioned, the superior courts, really, because I imagine the judge is listening to us right now, if they get to watch TV, that is. Listening to us right now, thinking, there's enough on my plate already. How much more can we handle? So that's why I'm looking for a way out. Is there an easy way out, or at least a semi-easy way out for the judiciary on this one?
Well, on legal issues, the only way out is the legal and judicial way. So I believe that we have Supreme Court. This will be done. And there is nothing more important than having issues resolved. Once they are resolved, the country has a lot of problems. So I think the Supreme Court has enough manpower right now to deal with these issues. It's a question of time, and they will be able to resolve all of them. But it's better that they do than those matters remain that way and the country remains deadlocked the way it is, economically and developmentally speaking.
All right, Associate Professor of Public Law, Rivers State University, Richard Wokocha, thank you so much for the interventions. These are things we have to do. We just need to ensure we get our acts right. As well as Mr. Stanley Ekpa, a legal practitioner, joining us from right here in our Abuja studio. It's good to have you on the show as well.
Thank you very much for having us.
And we take a moment now. We're still talking resources. Now, the resources are budgeted for, and then there's expenditure, the monies are spent, but then audit happens. So what comes up after the audit happens, and then we see irregularities? Now, this has been happening year after year after year. That's our next point of conversation. That your money as a taxpayer, how is it being spent? That's the moment. Stay with us.